Okay, sir.
Technology has its
Thank you
own.
so much. And so we welcome you all on this Saturday morning. Thank you for taking out time today for joining us on this webinar on DPDP Act, which is basically going to be implemented very soon in India. It is about data protection. And we have with us CA Rajeev Talwar ji. He is a very eminent professional, carrying almost more than 30 years of experience with him. He is a chartered accountant, he is a lawyer, he is a CPA from Australia. He has done his MBA finance in India, and he has also worked in US for quite some time in his early career. So Rajiv ji is doing a lot of work on DPDP Act, and he has been, a forebearer in this particular arena. And as we know that data protection is very, very important in today's time, and a lot of other countries and European Union have already implemented such laws in their jurisdictions. And it is now India's turn that they have also drafted and enacted an act which is called Digital Personal Data Protection Act 2023, and it's just waiting for getting implemented. And we will be talking about what are the responsibilities, what are the kind of obligations which we are having on us, because we are all chartered accountants dealing with sensitive and confidential information about our clients, individual or be it companies, how we are supposed to uh, handle that information, what kind of consents we are required to obtain from our clients, how should we maintain it, how should we protect it. All those kind of things are very, very relevant in today's time, and more in view of this particular act. So over to you, Rajiv sir. We are more eager to learn about this new act and the new obligations which are going to come along.
Thank you, Anshul, for that brief introduction. And let me tell you, I'm not an expert in anything. It's just that वो हिंदी में बोलते हैं ना, जब सर पे पड़ती है तो पढ़ना पड़ता है और करना पड़ता है, तो इट इज़ लाइक दैट. So and a very good morning to all the participants. Uh, it will be half an hour while I'll be talking, and the next half an hour will devote towards the tool, so that you get the understanding of the act and the flow in terms of the technology that is going to be backing this act. So as all we know, just to take it on from where Anshul was saying, that it is already implemented way back in August of 23, and 2 year timeline kind of a thing was given by the government to put your house in order and start doing your policies and terms and condition and your consent management procedures. So, and as of now, everybody, whether you are dealing with one person or whether you are dealing with crores of person, in terms of their digital data or any data which you convert into digital post taking a hard copy. So it's that wide in terms of the applicability side. So coming to the here. So as you can see, 2017, the Supreme Court recognized the Article 21 in terms of the Privacy Act. Then 23, it received the presidential assent. 25 is when the Data Protection Board has been established, and May 27 is the kickoff in terms of the full compliance of the Act, which is right from your consent till your breach. We'll come to that in the next slide. So here is it. What is digital personal data? So as I said, any data which is collected or collected and later digitized. So for example, in our case, while filing our clients tax returns or bookkeeping or any other compliance, we are seeking data either on the email or through hard copies in terms of files, and subsequently we are digitizing them and filing them on various portals, maybe GST, maybe income tax, maybe PF, maybe ESI, all those places. So in terms of our profession, we'll get covered in the act, and we'll have to take a consent. Now, the act says that consent will be very, very numerized in terms of what exactly are you going to ask that person to use that data for. For example, in our case, whether you're filing a tax return, compliance, bookkeeping, audit, transfer pricing, certification. If you're doing all, then take all. If you're doing one, then take one. That is the kind of detail which is required in the act. On the other side, many of you would have experienced that when we go out for malls, for shopping, people start asking, मोबाइल नंबर दे दो, आपको उस पर इन्वॉइस भेज देंगे, ईमेल दे दो, आपको प्रमोशंस आती रहेंगी, आपका लॉयल्टी कार्ड बना देंगे, So all those acts are now part of the consent. So while they are doing that collection of data, they have to take my consent electronically, not on the paper. Either they send a WhatsApp, either send an SMS with the tick boxes that do I want the marketing to happen, do I want the email to come in, or I just want the invoice. Apart from that, whosoever is dealing cross border, which is the European side, which is the American side, or on the South Asia side. So there will be a cross border applicability. So if a client is having a subsidiary in India, but they are sitting as a parent in UK, then UK GDPR will also kick in. Or if they are sitting in Germany, then the EU GDPR will kick in. So there is a cross tentacle that is going to happen when we are collecting data from somebody who's cross border. As I said, it applies to every sector, every size, whether it's an NGO where we give a donation, whether it's an individual, whether it's a startup, whether it's a business, either ways. We can ask questions in between also, that is not a problem. That will keep it more interactive. Now coming to the key definitions in terms of who is a data principal, fiduciary, processor and personal data. So data principal, as we all know, would be the one whose data we are wanting to use, the one who owns that data. For example, me means my mobile number, my email ID and probably my bank statement or my payslip, right? It is given to, say, Anshul. So he becomes the data fiduciary, the one who has to process it. Now, the fiduciary can also be a processor in the way that Anshul is receiving data from me, filing my tax return by using a utility from the income tax office. So he becomes a data fiduciary cum a processor. On the other side, if he uses a third party software, say for example Tally, then he becomes a fiduciary with a processor going to somebody else, which is called a sub-process. So in this entire link of three people, the consent will move from data principal to data fiduciary to data processor. So it's like a cascading impact, the way we have in GST. You pay it, I claim it. So the data principal has to be absolutely clear while giving a consent to the fiduciary in terms of what all that person would be using the data for. Same way the fiduciary has to very clearly mandate to the processor that I am handing over you the data. You will have to safeguard it, keep it absolutely safe, encrypted, etc., etc. Personal data, as we all know, anything which is related to me or you or anybody else, which is being used for various purposes apart from the financial data. So now coming to the act. Now the wonderful part is the act, the main sections are 5, 6, 7, 8, 9, 10, and 17. In these 6, 7 sections, the Act very clearly enumerates what all anybody has to do. The best part is, if you read this Act, they have given beautiful examples to explain each and every section. So, if tomorrow somebody has a iota of doubt, that example is very ground to earth in terms of the happenings which are happening on a daily basis. So you're able to relate to that example and understand that where all you apply and where all you don't apply. Sorry. So we start with the consent formalities, which starts at section 5. As I said, a very clear itemized notice. So we as a service provider has to send a clear notice to our client that we are going to use your data for A, B, C, D, and F. Now that consent has to be given by the client in terms of A, B, C, or D, or only A or B, whatever it may be. So they have to tick the box, and then that consent has to be stored by you. So in terms of technology, which we will come in the next half, all this will have to be digitized in terms of record keeping, so that you know whose consent has come in, whose consent has not come in, or probably who has withdrawn, and for whom you are not going to work anymore in terms of usage of data. But keeping in mind the basic law of maintaining data in terms of 8 years, as say for example income tax, you will have to safeguard that data into a secure place. Section 7 says that there are certain exceptions which apply without consent. So the main part is, I am seeking an employment. The employer is asking me for my payslip, my PAN card, or probably my Aadhaar card. That is one. Second is, I go to the website in the career section, I go apply my CV. Third is, I go to naukri.com, put my CV over for searching a job. Now all these categories they have put in as a voluntarily shared data, which carves out an exception to give a consent for usage of that data. There are others also, wherein the state may ask for certain information. There could be medical emergencies. All those things are there. But the basic in terms of section 7 is the sharing of data, where you do it voluntarily, as I gave the examples. Now here there is actually a small controversy in terms of what is voluntary, right? To my understanding, if I do not give a payslip or a Aadhaar card or a PAN card to my prospective employer, he won't give me a job. So by force of act, it is not voluntary, it is actually I am giving a consent to use my data. So there is a slight disconnect in terms of that being a voluntary action. Coming to section 8. Now section 8 is basically the obligations which have been given to the data fiduciary, the one who's going to use that data for the reasons where the consent has been given by the data principal. So he has to ensure, as always, data accuracy, breach, erasure of data if at all there is a withdrawal of consent, right? Securing the data into a very secure environment, putting into place the policies as to who, where, how that data would be accessed, in what manner, while the consent is on and while the withdrawal has taken place. There has to be a grievance mechanism. There has to be a window to address the breach. So tomorrow a client comes in and says, your article called me up and he said that please file your tax return with me, and I find it out that okay, boss, he was an ex article with ABC firm, and he has taken my data from there. So that firm has to prove now very categorically that it was not a breach from their records. Again, if you have to do all this kind of thing, you need a technology backbone to survive and produce those documents. That it was not a breach at your end, it was probably somewhere else. Any questions till now? I think none. I have
I don't think any questions as of now, so you can carry on. We'll open the house for questions later on.
done. So coming to the next section, which is section 9, which basically is the most important in terms of companies which are dealing with e-commerce or retail. Where people create their children accounts, or children create their own accounts on for buying and selling, or these social media platforms and everywhere else. So there, what they are saying is that that breach is the most important part. If anything happens in terms of that, the liabilities are very very severe. So in terms of the consent, they are saying that consent has to come from the parent or the legally owned guardian for processing of that data for that child. So here, for example, I have a birthday to celebrate for my niece, and I create an account on Amazon, create a gift voucher, put the address, put the amount, and send it to the concerned person. Now here, the first consent I am giving it to is the Amazon, where as a parental owner or guardian, I am telling them please use the data for providing a gift voucher to my niece. Second is that if it is being used by any other sub processor, maybe you're sending a gift, so a porter guy is using that address along with that phone number, then he becomes the sub processor, and he has to give a consent that that data is only used until the time the delivery is happening. So the moment the delivery happens, data vanishes from the screen of the users. But maybe yes, you have to maintain that data in terms of probably the porter as a company or Amazon as a company in to retain that data for any other purposes which the law may envisage. So probably a cyber crime cell may come up after 4 years or 5 years and say, boss, there was a crime done by this particular number, and please give us the details. So now you go back and search it out, and you see that there was a parcel that went out to this particular person, and the data is no longer there. So you are stuck. So that data has to be maintained in terms of very security to produce it as and when the authorities ask for. Next is the section 10. This is uh, this is akin to,
So
as
there
I
is one question.
yeah.
Sorry to interrupt. There is one question from Nitin Goyal. He's asking, does it apply to all data or just KYC kind of information?
No, it applies to all data, whether it is financial or whether it is non-financial, depending on the entity. See, for example, in a e-commerce retail platform, you will give a email, you will give your date of birth, you will give your anniversary, you will give your phone number. This is all you will give, right? In terms of financials, here you will give almost everything. Your bank statement, your online passwords, PAN card, Aadhaar card, etc., etc. On the NGO side, again, you will be sharing your financial data, because there will be a bank which will be involved to pay the payment. So all those things are there. So it applies to everyone and every single set of data. I hope, Nitin, that is understood.
Yeah, thank you.
Yeah, somebody wanted to ask a question, or do I move on? Shil,
Please move on, sir. Carry on.
Shilpi is asking any data which helps to.
No, no, she is asking actually. She is helping you out in
Acha.
the chat box.
Okay. Okay. So coming to section 10, uh, this is in terms of setting up an internal data protection officer. Right now, the Act says that there would be a data protection officer appointed by the company, irrespective of the size, as of now, to be notified later. So, and the biggest caveat is that that person has to be an independent person, not related to the company. So it won't be, a CEO mandated to be a DPO, or a marketing officer mandated to be a DPO, or an in-house legal counsel mandated to be a DPO, as of now, right? So this entire seat works like an independent director, which is a bridge between the customer oblique the government authorities one side, the entity on the other side. So tomorrow there is a breach. That breach has to be notified to the DPO. The DPO has to notify it to the data principal. The data principal then has to, go back and file probably a case before the council, that look, my data was breached by, say, by Amazon. There will be an inquiry happening. So that agency would be dealing with the DPO, not with anybody else in the company. So the DPO has to provide all the set of documents that look, here the consent was given, here it went, here it was safeguarded, it was not accessed by anyone, it was lying absolutely safe, there was no breach happening. There will be a full audit trail in terms of technology. Otherwise, in terms of data, it would be humongous to maintain a paper trail of going and coming, which is next to impossible to prove any kind of breach in terms of digital data. Second thing is that there has been mandated an audit as well on significant companies, which will be notified later, where the independent audit agency has to go in, create those internal checks and balances as we do in the IFC or the internal control, that where is the data resting, who is able to access it, what is the confidentiality of the data, right, when it can be accessed, who will give the approval, why it is required. All those checks and balances will now be done by the independent audit agency, and a full report be provided to the DPO, which in turn will give that report back to the management. These are
Sir, there's one question from my side.
Yeah,
If you can just move on to the last slide.
sorry.
So when we call a data protection officer, so is he liable to the authorities in any way for being responsible in maintaining the data and all those things, or he's just a bridge between the two entities and just extracting the documents and giving it to the authorities? So what are the liabilities of data protection officer?
See, the DPO acts exactly like an independent director, that if he finds on his own any breach, then he has to report. Otherwise, the company will have to inform the DPO that the breach has happened, and then the DPO will liaise with the state agencies or the customer or the individual that this has happened. There is no individual liability of the DPO. He is basically a bridge between the two entities.
So my question is basically, so if say for example a breach has happened somewhere and the company didn't report it to the DPO, and later on the authorities find out that this is something which has been going on, so is there any responsibility of the DPO to be fixed that you were not able to find it out? What were you doing sitting as a DPO?
Not really as of now. It is see what it says, the DPO who is accountable to the board, right? So basically what the DPO has to do is he has to keep a check through the independent data work or the internal controls. Time to time trying to find out and understand where there could be a breach happening, or maybe a breach has happened and subsequently discovered or not discovered.
Okay. And there is one more question from Gopal Nathani ji. He is asking, how about the documents, contracts, agreements shared as audit evidence to us? Do we as auditor or consultant need to give a consent to the client for these kind of documents also, because these will form part of the audit documentation, probably may not be forwarded to somebody else, just processed and kept as a record with our firm only.
No. The consent has to be given by the person who owns the data, right? So once the principal has shared the data, I have prepared those management representations, etc., based on that data. That is my working papers. So I don't have to give a consent to anyone.
No, so I need a consent from the client that, okay, I'll be maintaining these records as part of my audit process or audit documentation. And
Yes.
if any authorities come in later on, or maybe because the peer reviewer also looks at the files
Yes.
somewhere down the
Yes.
line.
Yes. Correct. So you will have when you take data services, audit services, then you will jot down the details in that preparation of financial details, taking working papers, including your management representation, etc. Because then the data fiduciary will become the data owner as well of that particular data where those MRs and other things have been prepared.
Right. So, okay.
Coming to section 11 to 14, wherein the rights of the data principal, which the person who owns the data, right? So at all times he has a right to access. Since he has given a consent, he has a right to access to his data. Wherever you may store it, that information he can always derive from you, that look boss, I gave you XYZ details, I want to have a look at it, how you are doing it, etc. Then if any correction is required, he can do it. If he says, I you know in by inadvertent error sent you XYZ which is lying with you on your email or your cloud based server or wherever it is, please erase it, right? So they have to you have to erase it. If he is not satisfied with the 3 points which are enlisted here, which is the right to access, correction or erasure, then you have to provide him a grievance window. In terms of a smaller organization, probably the DPO would be me and you, or probably somebody else, right? So they have to provide a grievance redressal in terms of solving the problem of that particular person. Acha, then there is a right to nominate as well, wherein, by example, there is a senior citizen who's given that financial data. By God's will or something, he passes away. Then his legal heirs are equally liable to take over that consent and seek access of that data and the usage of that data, which the data fiduciary has to comply with, or any other legal agency, as you may say, has to comply with. Section 15.
Sorry,
Yeah.
there is one more question from my side. Is there any examination, just like an independent director, which will be required to be passed by any person for being appointed as a DPO?
No. As of now, no.
So who is eligible to be appointed as DPO?
Anyone who's having a tech background and knowledge of the act.
So who will decide that?
See, that is up to the company. Who they think is a person who's not connected to the company, but yet has a wherewithal to understand the act and liaison with the authorities. As per my understanding, if you really say, lawyers are the best to be the DPOs, because there will be legalities involved in terms of sharing of data to an extent, or to what extent the authorities may ask. Like for example, one of the companies asked us that, what did they ask? Huh. Say that about 10 years down the line, CBI came over because there was some breach which had happened in terms of that particular phone number which was registered with them, and they started asking what all he purchased from our website, when did he do it, where all did it got for shipping, all those kind of things. So they said since we had retained that data, we were saved. But had we not retained that data, then probably there would have been some other kind of a legal action which would have taken place. So their in-house counsel was the best guy to liaise and give that data. हालांकि इसके ऊपर I am seeing people are doling out courses and issuing certificate courses on how to be a data processing officer. So basically,
but the law doesn't provide anything.
Law does not provide anything.
Okay.
So basically, to my understanding, somebody who is intelligent, who understands technology, who understands the process, is good enough to be a data processing officer.
Okay.
Coming to section 15, wherein the act complies with breach of data and everything. So basically it's an obligation which is both ways, which we all know, that it's not that since they have given a consent, so we are a free owner of that data. Vice versa, we are not the free owner, and hence we cannot take our data principal to be at our beck and call, and use that data for whatever other reasons we may so think so, right? So comply with the provisions of the law, not impersonate another person when providing personal data, in the sense that the data principal should not, sometimes what happens is people create pseudo emails, where the actual person is not there, but somebody else is there whose name is mentioned. He may or she may not be in the organization at all. That is one way of looking at it. Not suppressing any material information while providing for official documents, right? Again, this is the point where I was saying that a legal guy would be better to frame that particular understanding as to what is material information, and what all to comply, or probably what all not to comply with. Not to register frivolous complaints. This applies to a data principal. See, basically, to my understanding, a breach would open more doors for litigation, with probably fighting out clients who are looking at different ways to pick up fights. Probably, I don't know, where they want to depart, and the professional is not willing to part ways with them, holding back data for some reason or the other, payment nahi aayi, payment kam aayi, or whatever that reason may be. So all those obligations will start forming a matrix when a client is wanting to part ways. And second thing is, just a corollary to this, in terms of the e-commerce entities or the online retail entities, if a person has given a consent, created a data, but that person is not using that website for say probably 1 year, then the act says then that data can be withdrawn unilaterally as per section 7, that it can be withdrawn unilaterally by the entity and stored safely. So if I go back tomorrow 1 year down the line, I may not find my phone number or account active on say Amazon for some reason. So then I have to contact them, give them the information, the DPO will look into it and then restore my data. This is the section 18 to 29 which deals with the Data Protection Board, the appellate authority where anybody who's aggrieved will have to file their cases. It can be individual, it can be companies, it can be NGOs, it can be anyone. So there are rules and regulation around it. It works exactly like a tribunal. with the members and the chairperson, from the independent agencies, including the government. Then powers to, hear it out, adjudicate, apply penalties, hear applications on an urgent basis, and appeals again. Appeals go to TDSAT within 60 days, and further on to High Court and Supreme Court. This is the best part, where the penalties have been codified. So which starts from rupees 10,000 from section 15, which is on the data principle, then goes up to the companies for not implementing the safeguards, up to 250 crores. So those black datas or those black webs, where we keep hearing and we keep listening that our data for millions of people have been breached. So those companies will fall on the bracket number 1 of 250 cr worth of the penalties, or probably blacklisting it, or any other kind of punitive action that the authorities may want to do. The enforcement.
There are a couple of questions.
Yeah.
So Gopal Nathani ji is asking that, so we take consent to decide MRL.
Right.
That is probably a follow-up question about the audit process. That MRL is something wherein they are providing something about they're giving some declarations about the audit.
Yes.
Or the data which they have prepared.
Yes.
Right, as regards to the obligations of an auditor. But when we are storing and keeping those records in our own files and backup files, audit documentation, so whether a specific consent is still required from those clients in order to maintain that data?
No. Once he has given the consent under section 5, where itemized consent has been given, that I am going to use your data for audit. So then audit, again, there will be a list of details that we will maintain working papers in terms of MRL, a representation, your financial data. So all those things will be detailed out, and they will be my working papers, for which any other further consent is not required.
So, but at first initial instance, we are going to require a consent.
Yes.
That this data is going to be used for audit purposes, right?
Yes, correct.
So there is some positive action which is required from the clients, and even for the audit process.
Yes. For every, as I said, the section 5 says it has to be an itemized consent. So as detailed as we may be, would be good for us. Not keeping it in the gray area that okay boss, I just ticked out audit services और नीचे मैंने उस पर कोई itemized कुछ detail डाली नहीं, so I am done with.
So basically, for example, if we are dealing with some individual clients and we are having the data of what is their investment strategies, how they are following it, or if we have certain plans and strategies for their wealth management and we want to offer that, so we need to ask their consent first that okay, we can use their data to analyze and to offer more services. So is that also something which is going to be required at our end?
Yes. So what you will do is, then there will be an itemized line that wealth management advisory services. So there will be a drop down. Okay boss, I will use your balance sheet, I will use your bank statement, I will use your financials, I will use your previous share or demat accounts to analyze and give you the best possible scenarios to invest your money.
Right. So basically, this is quite a fair amount of work and load which is going to be put upon all the entities and including chartered accountants, because chartered accountants are also dealing with a lot of personal data.
Yes. Absolutely. It's a humongous task. See, the best part about section 5 is that it says itemized this thing. So that itemized is the one where no gray area can be left out. Because as I said, no, it would go into litigation sooner or later once the entire act is implemented in May of 27. As people start understanding, what are the liabilities and where all the breaches can happen or would happen, right? So then the refinements will start coming in. So until then, it is what my advice is, make it as itemized as possible to capture every single scenario which we are dealing with our clients.
Right. So when is it going to be actually implemented, come into force?
It is already into force in August of 23. Rules came in 25. The full-fledged implementation along with the tech backbone is May of 27.
May of 27. So it's not even 1 year down the line.
Yes. So what we have realized is maximum companies have created online policies and terms and condition. अच्छा मैं इस पे a good point. I will take a step back. Earlier what was happening? Earlier what was happening was we go to a website, there is a tick, terms and condition, privacy policy, tick, done with. Now we move on, we buy our goods, we close the website, and tomorrow we start getting calls. Like for example, our case, when we make a company, all the banks start setting us emails, आप मेरे पे account खुलवा लो, मेरे पे
Absolutely,
ये कर लो, वो
absolutely.
कर लो.
In fact, sometimes certificate of incorporation comes later and the
Yes,
bank's mail come earlier.
absolutely right. So this is that. So now when I'm doing that work, my client is giving me an information that this will not happen. Now I have to take a second.
So just holding back. So is that apply? Does that apply to the MCA authorities also? Because see, this is something which is MCA giving access to banks and all those companies who are providing us those emails for initial services and all those things. In fact, not even banks. There are a lot of consulting firm companies also coming, sending emails that we can provide you TDS, GST, and all those kind of services. So, is it going to apply to MCA kind of government authorities and government bodies also?
See, as of now, in the bare reading of the act, it applies to everyone. So probably, it might be happening in that masking format as Aadhaar, you know.
Mm-hmm.
So they might be working on it. I have no clue on that because these are all public domain details. So what exactly would be public domain details will have to be decided by the authorities as to how things will work out. Like for example, अभी वो जो WhatsApp is using those username kind of a thing, you know. So government is saying no, boss, you will only use the phone number, you will not use a username, right? So tomorrow when the act implements, then those numbers probably have to be masked or do something of that sort as to how that consent model will work in that.
I think government has different issue with the username. They are saying that my username, or say for example, government of India's username or department's username should be protected rather than they are being taken over by somebody very non-existent kind of a
हाँ
person,
हाँ.
and then blackmailing the government to take up that names or any kind of renowned names being taken up by some random persons and then selling it off for a very big name, just like Geo Hotstar happened a few years back.
Correct, correct. Well, see, basically that is in line with what the MCA does. So they don't give you a company name which is generic or matching out with somebody else, right? So that is the step one to deter the social media platforms from using usernames, because see, it will be very humongously impossible for them also to not allow a username to happen just because there is an India word used, right? Or probably prestige used, or probably Maruti used for any reason, you know. So, once this entire act rolls out, how these permutation combinations will be dealt with, only time will tell.
Okay, so let's come back to our topic. We have drifted away.
Huh. So, the last point is on this penalties part. So, the highest penalty hovers at 250, starting minimum at 150 for the companies where the data fiduciary duties have not been fulfilled. So, and this is where the maximum this thing lies. These are the timelines, as I said, you know. So till November 26, consent manager frameworks, as I said, the entire tech backbone and the registration and the consents etc. should start taking place and should be fully implemented by the May of 27. This is a brief in terms of what everybody has to do. So audit and map, rebuild consent flows. Rebuild kya, there won't be any consent flow, so people will have to start doing that. Fix how to deal with children's data, update contracts. Yes. So every professional oblique company has to put in a privacy policy, a terms and condition, and a data processing agreement, because most, rather 99.99% companies oblique professionals would be subcontracting certain amount of data to other parties as well. So that data processing agreement will tabulate who all those sub providers are. So if I'm giving it to Computax, if I'm giving it to income tax, GST, VAT, or probably to some other chartered firms, maybe in India, maybe outside India. So all those will have to be tabulated on your website and sorry, forming part of your.
Brinda, may I request you to kindly mute? Thank you.
Yeah, I did. I did.
Thank you. So everybody has to start doing that work and creating all those legal formalities on their website, apart from creating a workflow on the consent model side. Coming to prepare a breach response, again a tech background, SDF ready, which is basically for larger organizations where DPO and all those audit obligations need to be completed with. So this is my part, wherein I have explained you the theory part, and now for a brief workflow, I will pass it on to Mukesh. He will give you the presentation in terms of how the tool looks like and what all it can encompassate for either the professionals or the companies.
Right. So just before you hand over to Mukesh, let me welcome Mukesh. So he's part of GK Consulting, and he's collaborating with SAT Legal, which is Rajeev Talwarji's organization. And they have created a tool which is a very comprehensive electronic tool to comply with the DPDP Act, and it's really a very good head start for any organization to have this tool. So Mukesh is going to just give you a demo and how it works and how it can help the organizations in meeting the DPDP obligations. Over to you, Mukesh.
Hi, good afternoon, everyone. Thanks a lot, sir, for this forum. I think this is a great opportunity for all of us to understand what all are we doing, at least in DPDP, as a life cycle management, and what all data opportunities or data generation opportunities that we may have that is going up at this point in time. So what technology really does is,
so Mukesh, we are not able to see your screen. We are just looking at the questions and discussions only.
Just give me 1 second.
Yeah.
मैंने कॉपी कर दिया, उसको वहाँ पेस्ट कर ले.
कहाँ पेस्ट करना है?
यहीं पे ब्राउज़र में. हाँ. आ गई.
There we are. Just give me a second, I'll share the screen. Can you see the screen now from a DPDP system perspective?
No, not yet.
Okay.
Actually, Rajeev ji, if you can just stop sharing your screen, probably then.
I'm actually, I've decided to use the same laptop.
Same laptop?
I'm using the same laptop, I think, but I'll have to change the settings.
So probably he would have shared just one window.
Just one window. I'll share the whole screen. Just one.
Share the entire screen. So in the meantime, if someone else has any kind of questions, please go ahead. Rajeev ji is still there.
Is it visible now? Can you see this?
Yes. Visible, however, it's blurred.
I think it probably takes
now,
about
yes,
a minute to load.
It's clear now. It's clear.
So this is how the system really looks like from a chartered accountant standpoint. So first thing typically a chartered accountant does is actually they onboard a client. So I think it's a great insight that Sir gave about a life cycle on how data protection and data storage really works. Just to tell you how technology aligns with that is that it identifies, number one, whatever that your data collection opportunity areas are, how you save and store the data. There are certain organizations who store it on a register, piece of paper, files, physical files, ERP systems, customer relationship management systems, accounting systems. So the data goes into multiple systems at the same time. Sometimes we subconsciously don't even realize where all we end up entering the data, especially in the Excel files. So that is something that we probably need to be wary of whenever we start working on data piece. The life cycle is that we allow or we create opportunity to capture the customer data, which is when you onboard a client. There's some technical issue, probably it's not showing here. But I'll show you a client organization in the meanwhile. If you look at a client, can you guys see the client list also as well? Say some of them, say Trinetra, Acme.
Yes, we are
Yeah.
we are able to
So
see
the
it.
moment you look at it, you imagine the what all data that you collected for them. So you collected. So what was your engagement type? Your engagement type was you're doing a stat audit with someone, you're doing a GST TDS compliances, you're doing payroll outsourcing, you're doing forensic. So these are multiple opportunities for you to be able to ask and seek for more and more data. So this is your engagement that we normally talk about. It also tells you what kind of data that you normally collect. So you probably would have a master DPA signed with them. You will have an engagement letter signed with them. There will be a privacy note within the employee, within the organization and outside the organization also as well. If at all there is a payroll outsourcing, you probably would have created a data or a document there also as well. So you need to be able to figure out and map what all data collection opportunities at what engagement level are you seeking for. So first piece is understand and map your entire data universe. For example, when you onboard a client, you get their PAN number, GST number, TAN number, their organization details, sometimes even employee details, ownership structures, their financials, everything that you end up collecting. So you need to first define your data universe mapped to the engagement type, which the system really helps you do that. Then your engagements come into picture, where you simply see that if at all you did there was a whatever data categories it went into, you picked up their trial balance, you picked up their payroll, you also picked up their vendor PII. So that's also a very risky and a gray area where you end up going towards the third party areas as well, where you start seeking their vendor data as well during the audit and otherwise whenever that you're working with them. So first step is collect the data, understand what kind of data that you're collecting. You can actually conduct an exercise in terms of optimizing data requirements and try and make it as minimal as possible, which is relevant to having a working operations for you. It should not really become too much, and you can start capturing right here, and you can keep creating new engagements here as well. Now comes the consent management. So this is your complete life cycle from the consent standpoint. Now in a consent, first you draft the kind of consent that you really require. Like sir was talking about in the session earlier, that you figure out whatever consent opportunities that you may have. So if you're taking my balance sheet right now, you would simply say I am going to use it for taxation. I might even use it for due diligence. I might use it for any compliance filing that needs to be done. We might use it for performance analysis also as well. So you draft the opportunity, take the consent, the client reviews it. They simply say, okay, I will allow you to use it only for certain purposes. Do not go beyond those particular pieces. You approve. You get the approval from them. Then this approval is published in their CRM. It can be through an email that these are the consents we've already obtained, and you agreed to it, and they are not contesting it at all. And this is captured. Now the next three steps are even more important: modified, withdrawn, and archived. Now the moment I've captured the consent, most of the times in today's times, we assume any data that we are getting, it's a captured DPDP consent, deemed consent, and we do not really worry about it. But we need to allow all the clients to modify their consent. They can even withdraw their consent, and then it has to be archived for a particular stat requirement for a certain time that it can be audited for, so that we also do not really land up in any trouble tomorrow if at all there is any compliance requirement that comes in. So that's how the consent management really works. You can actually check the receipts, you can verify them offline, and that is what I was talking about through an email or otherwise. But this should be recorded in multiple systems that you may have at one point, every point in time. Now comes the consent template builder. Now you can actually build your own consent templates, which can either go out as an email. For example, about us, you can actually give out and simply say that these are the information that we are going to find from you. But from what my DPO officer, so every organization, like sir mentioned earlier, every data protection organization should have either a dedicated or a shared DPO who can actually validate and verify the data practices happening within the company. Then third is, you can, like I was talking about, the opportunities and the optimization of data. So third level, you go to the personal data collection like PAN, Aadhaar, address proof, photographs, mobile number, email IDs. Then you come the specified purpose. Like you mentioned, taxation, PF, ESI. This is also for your employees as well, anybody who's working with you. And then where all we share it. Now, for a CA, mostly, there's a very little amount of processing done, but most of the data and outputs and outcomes are submitted into a third party tool. It could be a client or it could be mostly government tools, whether it goes into Tally Cloud, HRMS, NSDL, DSCs, any other data, Provident Fund site or ESI site. So we submit this data into third parties sites also as well. That also has to be clearly explained to the client, and their consent should be obtained for usage of that particular information sharing also as well. That is very, very important, and that's recorded in the system right here. Now this tells you about your data inventory. That, for example, for a particular client, what all data have I captured is right here, that you can look at it. For the stat audit, we're simply picking up trial balance plus PII data. Where is it stored? It is very, very important. We are talking about on-prem, cloud storage, storage on a local server, storage on a local machine. How long will it be retained? Then, is there this data goes to a third party or not? Maybe a processing center, maybe through a third party tool that you may be using, maybe SAP, and inspection that we'll talk about DPI after this, how it is recorded. Then comes your DSR management. All the data that is coming to you, all the subject rights are mentioned right here. What exactly, at what stage, what kind of data is being picked up, and how much is being recorded. The system completely maintains the entire life cycle right here, so that anybody who wants to fetch it, you can actually present that particular data. This is your compliance checklist. Now this checklist completely tells you how far along are you in terms of your data management. It means, do you obtain valid customer data? Are you ensuring consent? Are you providing proper clear notice? Are you limiting data? So it tells you the health check of how your DPDP process is really working, and you can check whether this is being done properly or not. All these 47 checks within your system will help you understand if at all there is a breach. Like here we're talking about 7 are in progress, 3 are still open, and 29 are probably high risk items that need to be done. Now this is your data protection audit that you conduct right here. So you conducted, you figured out the risk score, you just scored 17/25, which is a high risk at this point in time. And who's the one who's reviewing it within your organization? If at all there are data breaches that are happening, that you should be able to understand all your scores right from here. Sorry. Then comes the breach management. It's very clearly laid out policy that certain amount of data breaches should be rectified within 48 hours or to maximum to 72 hours time. So within 72 hours time, any data breach means any untoward usage of data. For example, we end up calling using any personal data where the data consent is not given, and the person lodges a complaint saying that how did I receive a call while I very clearly mandated that this data should not really be used by anybody else. And that particular rectification should be done within 48 to 72 hours time. That's a government mandated guideline that needs to be done. Otherwise, we are subjected to penalties right here. This is a complete policy engine. How exactly do you build policies? It means you give a consent expiry warning that you're getting that the consent is about to expire in 30 days. It was only valid for this particular transaction. Now, for the next particular transaction that we need to do, we need to go out and obtain the consent all over again. Any escalation that is really happening, any breaches that we're really looking at from a data standpoint, any cross-border block, any children data. So any policy that you build right here for any rule for yourself, you can actually configure new rules through this particular tab that are right here. This is your complete workflow engine. Like we spoke about, that you draft, you review, you get it approved by the client, you publish it, you capture it. If at all there is a modification or a withdrawal request that is coming from a client that needs to be done right here, and then you archive it as per the policy for, there are some data points 1 year, then 3 years, then 7 years, depending on completely on that particular piece. From a DSR standpoint also, the same workflow that can happen. You can change the workflow as well if at all you require through the system itself. This is your document engine. All your clauses are mentioned right here. You can create new and more documents that you really want, and you can save it right here. And that is your complete end-to-end document, whether it's your DPA clauses, your privacy notes, consent forms, ROPA exports, retention policy, cookies, websites, DSR, all your complete policy engine from a document references is stored in one single place, so that tomorrow if you're also audited, you can show it through one single view. That can happen. This is your audit engine, which tells you about what kind of report that happened and what kind of action were taken against what kind of client. So your audits are also recorded, so that tomorrow anybody who wants the logs, that can work pretty well. This is your notification engine, that how many notifications have you sent through email, through website, through SMS, through WhatsApp, and all these notifications are well within the consent that has been given to you by the clients. Now this is the most important piece, the integrations, because so many times we don't even realize what all systems are we integrating to, or what all systems are we extracting data from. So all these particular pieces that we are talking about from an integration standpoint, all these integrations that you need to check, and you need to have consent for, if it is a third party system owned by someone else, all the data consents and everything has to become. And if at all there are in-house systems, then the integration from the logs in terms of accessing this data, accessed by who, everything should be obtained through these integrations, so that tomorrow you have a clear report, digital report, which will tell you eventually to your client that you did not allow anybody else to access their data without any permission that's been given to them. This is where you can create the user authorities who can see what kind of views that are available, and then you can set up your own organization the way you want it. So this is an end-to-end life cycle where you can obtain the consent, manage consent, allow the users to even withdraw or modify their consent structure. You can clearly define internal reports on where all the consent was utilized. Technologically, you can integrate with the systems where all the data sharing happens, so that any untoward or all the compliances against data usage can be presented to the client or any government agency who comes to, and you can get your internal audits done through the same system, and your audit reports are also within the system, and it's completely configurable for you to allow your policy management and document management through the system itself. So the system end-to-end captures your entire life cycle, right from obtaining data to retaining it, to auditing it, to maintaining logs of the usage of the data. I'm happy to answer any questions that you may have.
Thanks, Mukesh. Thanks for detailed description of this tool, and it's really helpful. We have a few questions out here, and we'll wrap it up very soon. So we have one question that DPDP Act applies to personal data. So why are we talking about corporate entities and all those things?
See, data is number one. The personal data is not a single individual identity. Every organization have their respective identity as well, whether in terms of GST usage, PAN usage, TAN usage, because those identities are created with the ministry as well. Second, all the transactions that they typically do, they all fall under privacy policies of the government, because they are financial transactions in nature. Some of them are made public as part of the MCA requirements, but most of them are not supposed to be public, especially the transactional data. What you get is in summaries. That is how it so happens. So that is where those technological data that needs to be done. And thirdly, this data in the hands of third party is also used a lot in misuse happens a lot in terms of insider information, espionage. There are a lot of other aspects also as well where this particular information needs to be protected. So that is also a part of it. So digital personal means the digital identity of the organization also falls into that.
Okay. Then we have another question. Does the tool also provide and make documents in the document engine and other document required for each client in the customized way, such as privacy policy, DPA, etc.?
There are external tools that we have that can get integrated with it so that the AI based documentation that can take place.
Okay. And then we have another question from Shilpi. She's asking, does this tool itself store data? If yes, where is the server?
So the tool, so that is depends upon the policy and how you would wish to use the tool. You can actually have an on-premises tool. Mostly people are seeking for an on-premises usage of this particular tool. So when it happens on-prem, then it is within your servers. The data, an entire set will be within your own servers out there. Or we can configure a private cloud for you where the private cloud data will be stored purely for your access. We're not doing it in open cloud right now because we're also exploring the privacy policies there.
Great. If we do not have any other questions, we'll close the session for today, and we will definitely have a follow-up session because I think that this will need more deliberation as we go along, and there will be a lot of other queries which will keep on coming. And as we read along with this particular act and we get familiar with the obligations there, it is more likely than not that we'll have more follow-up queries, questions about how we can maintain, how this tool is going to help us around. So thank you so much, Rajeev ji. Thank you so much, Mukesh, for taking out time on a Saturday morning. And thank you for all the participants for joining in and making this session very interactive and very enriching. So please do let us know your feedback. What do you like, or what improvement would you like in the next sessions? And if any other topic you want to conduct a session by the Let's Share community, we will be happy to do that. Please do let us know. We had shared you an email. You can respond to that email, or most likely you will have my mobile number. You can reach out to me there as well. Thanks a lot.
One parting note, Anshul,
Yes.
the question on privacy policy and terms and condition will remain standard across the board. It cannot be customized for any client or
Right.
any particular individual, right? And second thing is taking a step back, where Gopalji had a question that, I will take an MRI and prepare my working notes and everything. There, I will become the data owner in terms of the refinement of that data.
Correct.
एक है कि मैंने वो डेटा लिया और एज इट इज़ पंच कर दिया. दूसरा है मैंने डेटा लिया और उसके अपने हिसाब से टेलर करा फॉर माई ओन कंजम्पशन. सो आई विल स्टेप इन टू द शूज ऑफ द डेटा प्रिंसिपल कम द डेटा फिड्यूशरी. तो उसका यूजेज क्या होगा, उसको मैं डिस्ट्रॉय करूँगा या नहीं करूँगा, दैट विल रेस्ट ऑन मी, नॉट द पर्सन हु हैड ओरिजिनली गिवन दैट डेटा. So I said let me just clarify, it just occurred to me. But anyhow, a good session, and thank you everyone, and thank you to you as well.
Thanks. Thank you, sir. So we close this session for today.
Right.
Thanks, everyone.
Bye bye. Thank you.
Bye.
ये कहाँ है?
क्विक टेम्पलेट है,
मैं भी तो वही देख रहा हूँ.
हाँ?
बंद हो गया.
चल करें.
चल रहा है।
एक्सपोर्ट का ऑप्शन होगा ना। रिकॉर्डिंग कैसे होती है?
पहले तो बंद करो ना। हाउ डू आई सेव?
मूवी है ना, यही खुलेगा।
हम्म?
मूवी है ना, वही खुलेगा, वो वीडियो है वो।
तो बंद तो करा नहीं।
खोलो, कंटिन्यू करो ना, नीचे वो टैब पे। ये कौन सी रिकॉर्डिंग करी आपने?
ये तो मेरा उसकी है। हाँ चला गया। ये कौन सी है पता नहीं।
रिसेंट में जाके देखो, ऊपर रिसेंट है ना। गो टू दैट, गो टू क्विक टाइम प्ले, नीचे वो तो कॉलम है, टेम्पलेट की फाइल है।
ये
हाँ,
नहीं, ये तो वो है।
क्विक टाइम प्ले खोलो एक मिनट। बंद तो नहीं कर दिया गलती से आपने?
नहीं, मैंने तो कुछ भी नहीं करा।
रिसेंट में जाओ ऊपर, ये रिसेंट से आपने नहीं, इसी टैब में रिसेंट सेव ही नहीं हुआ ये ना।
25 है रे।
2025 में ये
कहाँ गई?
ले,
कर लो बात।
धोखा हो गया,
तो जी मीट पर करी का है तूने?
क्योंकि दूसरा आपको टूल ही नहीं है रिकॉर्डिंग करने का।
क्यों, वो में नहीं होता?
नहीं होती ना,
अच्छा,
तो
वो
प्रोफेशनल लेना पड़ेगा ना।
जूम है
जूम
ना?
का भी प्रोफेशनल लेना पड़ता है।
अच्छा, नॉर्मल में नहीं होती?
नहीं होती, 1.5 घंटा कॉल चल गई, जूम 40 मिनट में काट देगा।
हाँ, लॉस हो गया भैया फिर तो। मेरी ये चल रही है देख,
वही ना, इट इज स्टिल वर्किंग।
स्टिल वर्किंग।
वही चेक करते हैं इसमें, सेव करो।
ओपन फाइल।
गूगल करो हाउ टू retrieve a क्विक टाइम प्लेयर फाइल इन मैक।
हाउ टू
हाउ टू स्टॉप स्क्रीन रिकॉर्डिंग इन क्विक टाइम प्लेयर।
मैक।
कीबोर्ड शॉर्टकट देगा।
तो कुछ नहीं आ रहा।
वो रहा ना, इधर कहीं है ना बटन।